You.
Where mira.
All right, and get started. All right, doing business for trust. Though a trust can engage in any manner of business under declaration, the only thing to bar trust from conducting a field business in any certain jurisdiction is the public policy of that jurisdiction. So, like for instance, um, if you wanted to get into, like you wanted to open a barbershop, no, not that hard to open up a barbershop. You uh, for a barbershop. It's pretty easy. It's easier to open a barbershop than it is to get into shipping, trying to ship um, nuclear reactors or something internationally. Then you'll have a much harder time in that jurisdiction trying to kind of operate there. There's a two-part due notice rule. Uh, Sufficiently distinguish and represent the nature of the trust to the party with whom is doing business. You can use trust. You can add trust to the name of your trust. Um, um, and also state in plain, clear language in all written contracts um, obligations that the trust only is liable for its obligations and that neither the trustee nor beneficiaries are held to any personal liability in the contract. You should also utilize a PO box to obtain a separate shipping address, mailing location, trust. Limiting liability, trustee designation of title is not sufficient to limit liability or remove risk to his own individual assets. Um, must employ proper language either within the terms of the contract or above or beneath his signature or any proper place where it appears unambiguous. Any form of the word that will convey to the other party that he is dealing with express trust. You should also have a trust certification, which is like a pretty much an abstract trust is. I'm gonna get to that here. Banking, the trustee may open any business checking account, financial account, etc. Authorized, but doing so, trust is participating in the unincorporated interstate banking association. You should get a trust. You should get an account, the non-interest bearing checking account. You don't want to avail yourself of that benefit. You just want to be able to hold your finance secured that way. You don't want to avail it for them to make a profit. You only want to give them enough information to open the account. Um, you may, if you want to, you can get a credit card in the trust name, because we know some other things that we can apply as far as with the A4B process, uh, zeroing your account process. Yeah, open a non-interest bearing checking account. Want to maintain your minimum balance. Um, you can use postal money orders or bank certified checks, corporate money orders, sending interstate payments. It's also a good idea to be bonded as a trust. But we all have bonds already, so we don't necessarily have to worry anything about that extra step. When going to open your account, you can assign an agent to do that. Then that's where you would need this original notarized letter of authorization, where you're saying that the agent is able to open the account. What I did, I had a copy of the certificate of trust that I took as a trustee. and I said I want to change this account to a trust account, and they asked to see this certificate of trust. Certificate of trust is going to tell them everything that they need to know, for the most part, that they need to know to do what they need. You can have the copy of the trustee appointment. That's not required. Any of these other parts are not necessarily required. All you really need is to have that certificate of trust. And you should definitely get a separate EIN for the trust. No, not use your social, not use security. Though there may be times where you may have to use the social security number, but you want to establish trust as its own separate entity completely. Here's how you apply for a EIN number. If no one's familiar with that process, got two different types: the domestic, foreign. In our case, I would recommend foreign. Do a foreign EIN number. Go through that. You can. I called. They got mine. Fax it in. Your application in. There's also special instructions, like if you're trying to get a foreign EIN, you should not have the word domestic anywhere in the name of your trust. Though I read those rules, for some reason, I still decided to put domestic in the name of my trust. A couple other times, I attempted. In my head, though, I was thinking as domestic as in home, but when you're talking to the IRS, you're speaking in IRSese or whatever you want to describe their language, and they have in their instructions down here. They tell you exactly what it takes to do step by step. It's kind of like foolproof, but unless you're like me, you can still be a fool. You know, like that. I don't know if you watched the Simpsons movie, and they like boarded off the pond where they was dumping all the illegal waste and stuff. And Homer still found a way to do it. Like that was me. Don't feel bad if you don't get it. You know? Okay, transferring assets is four different ways to get assets into the trust. You can buy something, say it's similar to purchase, but this is put buy in precious metal, purchase in negotiable exchange based on barter system by assignment. Initially, you're going to be placing things in the trust by assignment. You're going to be trying to get in all the assets that you hold currently into your trust. And you can have like a formal letter for assignment, or you can just go and say you have a car, you go down to title bureau, you say, I want to transfer this, I want to transfer title from me to this trust, my name to the trust. And they'll do that. Just make sure you have your certificate of trust with you. And an ID that matches. If you have your L, if you have your trustee written on your trust certification as your name, L or Bay, that's what you better have an ID, a state ID from them that says L or Bay, because they do not have to respect um, any other form of ID. Um, as a trustee, you can make purchases from the trust for your own personal, but um, that's kind of the piece of purpose of what we're doing here. So I'm gonna go ahead and skip this slide here. Um, But oh, also I do want to say this though. You do want to make sure that you're you're doing things that everything is like laid out and it's plain, clear, and you can clearly follow what's going on. You don't want to try to muddy the waters in this process. Here's what here again here. Recommendation of transparency. You want to understand your objective as a trustee. Okay. So as a trustee, the trust is to hold assets for the benefit of the beneficiary. So as a trustee, you're not necessarily trying to like make a whole lot of profit or make things like really difficult. You want to get things done as quickly, simply as possible. And your main objective is to gather assets, to collect assets to hold. So remember that. Um, Here's some information about the Coinage Act. We're pretty much up to date with that. We have our bonds. We've read somewhat on this, but I have information on there. Don't want to get rare coins. Want to make sure your coins meet the Coinage Act standard. Lawful money here. And also, when when you're assigning assets, um, on your trust certification, it should say how assets should be taken into the trustee name upon transfer. And that should say something along the lines of John Doe Bay trustee. Um, you can write the trust name, the situs date, the effective date that went into action, or you could just put like, or you could put like any variation of trustee's name signed as trustee. All right, issuing certificates and bonds. Trustee can issue to whomever he chooses. It's a total of 100 units of capital interest and trust and beneficial interest. You can't go over 100 in either way. Um, as a trustee, you can you can mix those. You can make that like half a share or somebody like you want to give beneficiaries half a share and all the beneficiaries have half a share. So then you can have 200 beneficiaries or something like that. You could do that, but you can only have 100 total. Like I said, you can determine the amount of shares that one person hold. Um, to issue, they could work uh, alone as a trustee or jointly as the board of trustee. And want to execute under seal. Oh man! And you want to deliver those certificates as the original certificate. And you should record in minutes what's going on, and place that in the appropriate schedule. The, the same procedure for capital certificates. Instead of a beneficiary, is an exchanger. Bonds. A bond is an obligation or promise to pay money or to do some act upon the occurrence of certain circumstances. Trust need only issue the bond according to the particular transaction. To raise capital from outside investors in the form of IOUs, etc. Distinguishing feature of a bond is that The document shows obligation to pay some fixed amount of money or service at a definite time, state interest, stated. Uh, no rule against the trustee exchanging for his individual property for capital interest or beneficial shares in the trust. Must be able to pass a control test. Uh, this here is what we all be going through here. You got to pass a control test. You can't be essentially if you're the grantor, you can't be the only trustee and the only beneficiary. There needs to either be if you're the grantor, it needs to either be two trustees and you as a beneficiary, or you as a trustee and multiple beneficiaries. No beneficiary is to have a controlling interest in the trust. That violates trust concepts and constitutional law. And then you're operating as a breach of trust, and that third party can come in and get you, and we don't want that. Here, if you fail the control test, trust is looked at as an alter ego, hence may be proceeded against as though the trust does not exist. That defeats the purpose, same as making a revocable trust. We don't want to defeat the purpose of all the work that we put in. We want to keep everybody on the outside of that fence. All right, we're keeping minutes. The duty of the trustees to keep minutes for all resolutions, decisions, and acts done in the administration of the trust. This also will suffice for accounting needs, but it's recommended to keep a more detailed record of accounting. If it's just you as a trustee, you don't necessarily have to have a meeting. Just keep track of decisions, key decisions that you're making, management of the trust. Okay, and use billing and legal affairs. Pretty much what we're going to be doing is challenging jurisdiction, because what we're saying is, again, as a trustee, we're saying we're that private citizen. We're not the 14th Amendment. So you can't tell me what I can do and can't do as a private citizen, because I'm not operating. I'm making sure I limit my liability to not be in your jurisdiction of the 14th. That's pretty much what these next slides are going to be breaking down. I'm going to just go ahead and go through this jurisdiction definition, though. Jurisdiction now, government's general power to exercise authority over all persons and things within its territory. 2, court's power to decide a case or issue a decree. 3, a geographic area in which political or judicial authority may be exercised. 4, political or judicial subdivision in such an area. These are the different ways we would be challenging jurisdiction. I want to highlight this. As of 1938, most courts in America have changed in operation law. Courts of limited jurisdiction, limited to cases involving subject matter of the 14th Amendment public trust, makes it clear all are inherently federal. It's something that's been hit on a lot in what we have to be studying. Works Coriano. This is basically the same information. Okay, you get courts must have all three essential to say they have jurisdiction to determine jurisdiction over the subject matter of the case, and jurisdiction over the parties to If the court is lacking either, it is without power to decide the case, and any order, decree, or judgment other than a dismissal is void. Subject matter jurisdiction is statutory or common law authority of the court to hear the case. The appearance of testimony of a competent fact. So they wouldn't have subject matter jurisdiction trust common law, and we've already established that the courts deal with statutory federal 14th Amendment, so they don't have jurisdiction that way. And it can never be waived and cannot be obtained by lapse of time, consent of parties. So you can't even give them, even if you wanted to give them jurisdiction, you couldn't give them jurisdiction. That's what that is saying. And basically what we're trying to prove is fraud upon the court, the judge's failure to follow proper procedure, the unlawful activity or undisclosed conflict of interest of the judges, court exceeding its statutory authority, violation of due process, improper representation of a party before the court, improper issuance of a summons or defective service process, proper notice of being given to all parties by the movement, the court basing its order or judgment upon a void order or judgment, and violation of public policy. This is what we're trying to prove, get them that they're not going to say that they're doing, but that's what we want to back them in the corner. We want to back them. Okay, so here another breakdown. Okay, so you got presence. This is how they can establish jurisdiction. Presence, being served with a copy of the summons and complaint while physically present in the forum jurisdiction. A domicile, residence alone is a basis for exercising jurisdiction. In case of corpse, domicile is the state in which they are incorporated. In the case of express trust, the place of situs. Permission or consent, trustees personally or on behalf of the trust having not been properly served can nevertheless give the forum court permission to exercise jurisdiction. Depending on the act of the trustee, permission can be given well in advance of any lawsuit filed, and the consent can also be implied. Minimum contracts, having sufficient dealings or affiliations with the forum jurisdiction, which make it reasonable to require the trustee to defend a lawsuit brought in the forum state. The state has no contracts, ties, or relations with the trust or trustees. Personal jurisdiction cannot be obtained. Okay, here's 4 principles of minimum contracts. The trustee activity must be continuous or systematic in the forum jurisdiction, and the cause of the action must be related to the activity. Sporadic or casual activity of the trust and the forum jurisdiction does not justify the exercise of jurisdiction reasonable in general. The trust contracts are sufficiently substantial and of such a nature as to make the exercise of jurisdiction reasonable. General jurisdiction may be exercised by the forum over the trust or trustee. If the trust or trustee's activity is sporadic or consists only of a single act, the specific jurisdiction may be exercised by the forum only when the cause of action arises of the activity or act. So this is why we need to be careful how we contract and who we're contracting. As you see, the more times you contract with them, the more different ways they can try to exercise jurisdiction. Once personal jurisdiction is obtained, it can rarely be lost. We also have the extra benefit of being Moors to have another challenge up our sleeve. Go ahead and kind of skip past that because we touched on it. Maintaining proper IRS relations. The IRS is the legal entity duly authorized to collect association dues, income taxes from those who avail themselves of privileged immunities. Persons under this system have relative rights to life, liberty, and property. Their natural rights are turned into privileges and immunities. The IRS taxpayer relationship by operation of law is that of a beneficiary, cesticate trust to trustee. That's the same thing that we created, except theirs is public. You should utilize IRS Forms 56 to sign a fiduciary. That fiduciary should be a senior agent. From an example that I've seen Brother Toriano do, he assigned the treasurer of the treasury. And that's what I did when I did mine. You should also you should be telling your fiduciary to file forms 1099, 1096, and 1040 if you availed your trust to the benefit. Okay, in conclusion, goal is to own nothing and control everything privately. A trustee is the legal owner of the trust corpus. They have limited liability via the trust indenture and cardinal virtues, cardinal virtues of the trustee. It is limited liabilities likens the express trust to a corporation. Express trusts operate in the common law, where corporations operate in the Roman civil law. A trust is the most effective way of achieving the goal, supporting legal health and commercial wellness. Here goes some questions. Trust the same as a will? No. A will is a letter to the court providing instructions for assets to be distributed after a death. A trust is a contract that contains instructions on how assets are to be handled while the grantor is alive. At the death of the grantor, the minutes trust delineate what is to be done, when and how. A trust serves as substitute, but far superior to a will. They also can be used in conjunction as well. Again, the point of us putting this trust together is to avoid actually even the need of a will, because the will would go to probate, and you're telling probate what to do with the estate, as opposed to putting it in trust and it's already taken care of privately. What is asset protection planning? The adoption of advanced planning techniques which place assets beyond the reach of future potential creditors, which is what we're doing here. Should my bank set up my trust and be the trustee? No, unless you think the bank has your best interest at heart. Should an attorney help set up the trust? Can. There are typically large fees associated with acquiring attorney services. You may also find it difficult to find an attorney who understands inter vivos trust. That inter vivos just means a living trust. It takes effect during the life of grantor. That's what I created. That's what you would be creating if you create a trust. Take place action during the course of your life. Is this considered my trust? No, you are in control of the trust if you are the managing director trustee. The trust is its own separate entity. Should I establish more than one trust? You should have total asset protection. Multiple trusts would not hurt, not required. You want one trust, you can do one trust. Is there a limit on property I must own in order to create a trust? No, you don't have to be of a certain wealth or status to have a trust. That's what if you go speak to a lawyer, that's what they may tell you. Like, you don't make enough or you don't have enough to even put in a trust. So That'd be one benefit of being able to do a trust yourself, set it up yourself. What are some disadvantages of a trust? Sometimes it's harder to get credit in the name of the trust. It can be difficult for grantor to treat trust corporates as no longer belonging to him. Corporates transferred into trust cannot be transferred back into the name of the grantor in the case of irrevocable. Grantor does not have legal or equitable title to property. I say this, one thing I'm running into is transferring my phone account to the trust name. They're saying that the trust doesn't have enough business credit. Not even necessarily credit, that it hasn't even been around long enough. They say that they with Verizon, they look at a year, like to say if it's been around long enough. They want to require a large down deposit, security deposit, in order to open up a phone, a business phones line with Verizon. When one of the trustees dies, does the trust have to file legal papers of any kind? No. If the sole trustee dies without a successor trustee, will record without without a successor trustee. This person would record their designation with death certificate of previous trustee with the county recorder and file a new affidavit that he is the new trustee trust, or basically create a new trust certification saying who the trustee is. My employer makes out my paycheck directly to the trust. Will that exempt me from taxes? Now, if the employer maintains the Social Security number as an employee on his books, security is withheld, and the company has not contracted with the trust. To be exempt, the employer must contract directly with the trust and not specify who is to do the work. I would recommend you use IRS Form W8BNE in lieu of Form W4 with the employer. W8BNE is basically saying that the finances generated from this direct participation is to go to the trust and not to you personally. If I move to another state, do I have to record the trust there? No. Does the trust exempt me from property and sales tax? No. Here's the reference. That's the presentation. If anybody else had some questions, take those. We got like 3 minutes. We can get back on. I can answer some more questions. Guys, let me know what you want to do at this point.